A unanimous Supreme Court ruling dropped this morning that attorneys nationwide are calling the most significant civil rights decision in 3 decades. And here's the angle nobody's covering. This case wasn't merely about firearms. This 9-0 verdict completely overhauled the guidelines for police searches, automobile stops, and how officers engage with armed civilians. Whether you possess a weapon, carry concealed, or value your Fourth Amendment protections against unreasonable searches and seizures. What I'm about to unpack alters the entire landscape. Smash that subscribe button immediately, because this unanimous verdict impacts every firearm owner and every citizen who has ever been stopped by law enforcement. The reality that every single justice concurred, from progressives to originalists, reveals just how severely police departments were trampling constitutional protections. Here's the situation. On April 23, 2026, the Supreme Court delivered its verdict in Williams versus Michigan State Police, a matter concerning a concealed permit holder who endured a vehicle search during an ordinary traffic stop purely because he reported possessing a firearm. The justices ruled 9-0 that the mere existence of a lawful firearm fails to establish reasonable suspicion or probable cause for any search. Even more critically, the court determined that officers cannot leverage legal firearm ownership as grounds for prolonging traffic stops, commanding individuals to exit vehicles, or performing Terry frisks. Justice Kagan authored the majority opinion, supported by the remaining 8 justices. Consider this pivotal wording: the Second Amendment safeguards the right to keep and bear arms. The Fourth Amendment guards against unreasonable searches and seizures. Law enforcement cannot erase one constitutional protection to probe the exercise of another lawful ownership of a firearm. By itself does not generate reasonable suspicion of unlawful conduct. Let me dissect precisely what this signifies, how it defends both your firearm rights and personal privacy, what officers may and may not do going forward, and the essential knowledge you require to safeguard yourself during automobile stops. Number 1. Here's what the Supreme Court established in this historic 9-0 verdict. The court laid down 5 explicit guidelines that officers must obey when engaging with armed civilians during traffic stops and additional encounters. Rule 1: officers cannot search your automobile merely because you inform them you possess a firearm. Prior to this verdict, numerous agencies instructed officers that firearm disclosure warranted vehicle searches for officer protection. That practice is now unconstitutional. Rule 2: officers cannot prolong a traffic stop to interrogate you about your firearm past verifying you're lawfully permitted to possess it. If you hold a valid carry license or reside in a constitutional carry jurisdiction, officers must conclude the stop as they would with any ordinary motorist. Rule 3: officers cannot command you to exit your automobile exclusively because you're armed. Pennsylvania versus Mims permits officers to order individuals out during stops, but this fresh ruling declares the firearm itself cannot serve as the justification. Rule 4: officers cannot execute a Terry frisk merely because you reported possessing a firearm. Terry frisks demand reasonable suspicion that you're armed and dangerous. Legal carry means you're armed, yet it doesn't render you dangerous. Rule 5: officers cannot exploit your denial to permit a search as rationale for deploying a K-9 unit or prolonged detention. If the traffic infraction is resolved and you're lawfully armed, you must be permitted to depart. These 5 guidelines fundamentally transform officer-civilian interactions involving firearms. Before this verdict, in numerous jurisdictions, informing an officer you possessed a firearm triggered automatic vehicle searches, questioning and holding. Now, lawful firearm ownership is handled like any other lawful conduct, unrelated to the stop. Number 2, the lawsuit that produced this verdict. Anthony Williams was a Michigan concealed permit holder stopped for a malfunctioning taillight in 2024. Michigan mandates duty to inform. Therefore, Williams promptly informed the officer he held a CPL and a loaded handgun in his center console. The officer commanded Williams to exit, then searched the entire automobile for 45 minutes, citing officer safety justifications. Williams was entirely lawful. Nothing unlawful discovered. Yet the officer interrogated him regarding where he acquired the firearm, why he was carrying, where he was headed, and any prior arrests. Williams filed suit for Fourth Amendment violations. Lower tribunals backed the officers, arguing firearm possession generated safety concerns. The Supreme Court reversed unanimously, declaring legal firearm possession cannot rationalize warrantless searches. Justice Kagan penned, "The cost of exercising Second Amendment protections cannot be the forfeiture of Fourth Amendment safeguards. Number 3. Here's what this implies for you during traffic stops. This verdict generates particular protections you can activate, but you must understand precisely what to articulate and how to behave when pulled over in a duty to inform. Jurisdiction officer, I'm notifying you, as mandated by statute, that I possess a valid carry license and I'm lawfully armed. My hands remain on the steering wheel. That's sufficient. You've satisfied your obligation. If the officer inquires where the firearm is, you may respond, I decline to answer inquiries beyond my notification obligation. If they request to search, you declare, I do not permit searches when pulled over in a non-duty to inform jurisdiction. You bear no duty to volunteer that you're armed. If questioned, you may say, I decline to answer inquiries. Am I free to depart? If they observe the firearm, remain composed, keep hands in plain sight, and invoke your Fourth Amendment protections. I do not permit any searches if commanded to exit the automobile. I'm complying with your command. I do not permit searches or seizures. I'm invoking my Fourth Amendment protections under Williams versus Michigan State Police. This signals to officers that you understand the law. If they search, regardless, do not resist. State clearly, I do not permit this search. I'm invoking my Fourth Amendment protections. Record everything. You'll contest the search subsequently in court. Brief legal disclaimer, this is instructional material regarding the Supreme Court verdict and your constitutional protections. This does not constitute legal counsel. If you're confronting criminal charges or civil rights infringements, promptly retain an attorney who focuses on criminal defense and civil rights litigation. Number 4. Here are the critical exceptions where officers may still search your automobile. Grasping these exceptions is vital because officers will seek methods to circumvent this verdict. Exception 1, probable cause of an offense unrelated to firearm possession if officers detect marijuana, observe open alcohol containers, or possess alternative probable cause. They may search. The verdict only forbids searches founded exclusively on legal firearm possession. Exception 2, plain view doctrine. If officers observe something unlawful in plain sight during a lawful stop, they may seize it and search. Yet they cannot manipulate your possessions to manufacture plain sight. Exception 3, search incident to arrest. If you're arrested for a traffic offense like Dewey, officers may search your automobile, but they cannot arrest you solely because you possess a firearm. Exception 4, consent. If you permit a search, officers may search. Never permit. Always declare, I do not permit searches. Exception 5, inventory searches. If your automobile is impounded, officers may inventory contents, but they require a legitimate basis to impound beyond firearm possession. The essential point is officers require independent legal justification for searches. Legal firearm possession alone is never sufficient. Number 5, what officers are being instructed and how they're circumventing this verdict. Training directives from multiple agencies reveal these tactics. Tactic 1, request consent before referencing the firearm. Mind if I peek in your car? Always refuse consent. Tactic 2, claim they detect marijuana odor, remains probable cause in numerous jurisdictions. Tactic 3, deploy K9 units. Williams doesn't bar K9 searches, but does bar prolonging stops to await dogs. Tactic 4, isolate you from the automobile to interrogate you attempting to extract incriminating statements. Tactic 5, claim furtive movements to manufacture reasonable suspicion. Keep hands on wheel from the outset. Number 6, here's why this 9-0 verdict carries such weight beyond merely firearm rights. The reality that every justice concurred, including justices who generally endorse law enforcement and firearm restrictions, reveals how outrageous officer conduct had grown. Justice Kagan is recognized for deferring to officers in Fourth Amendment matters, yet she authored this opinion striking down officer searches that reveals the practice was so pervasive and unconstitutional that even officer-friendly justices couldn't endorse it. The 9-0 tally transmits a signal to agencies nationwide. You cannot exploit lawful firearm possession as a fishing expedition for alternative offenses. The court penetrated the officer safety pretext and identified it for what it was, a mechanism to search automobiles without probable cause. This verdict also defends millions of citizens who aren't firearm owners. The Fourth Amendment principles established here apply to any scenario where officers use lawful activity as justification for searches. Officers can't search you for lawfully carrying a firearm. They can't search you for other lawful activities either. Number 7, here's your strategy to defend both your Second and Fourth Amendment protections. Action. Step 1. Memorize your jurisdiction's duty to inform statute. Understand whether you must disclose or may remain silent regarding firearms. Never volunteer additional information beyond what's legally mandated. Action. Step 2. Rehearse the traffic stop script. I do not permit searches. I'm invoking my Fourth Amendment protections under Williams versus Michigan State Police. Am I free to depart? Recite it aloud until it becomes automatic. Action. Step 3. Equip a dashboard camera that captures audio. Numerous civil rights violations occur during traffic stops. Video documentation is essential if you need to sue for constitutional infringements. Action. Step 4. Never permit searches. Even if you possess nothing to conceal, consent surrenders your Fourth Amendment protections and permits officers to search without boundaries. Action. Step 5. If your protections are violated, document everything. Record badge numbers, names, times what was uttered and what was searched. File a grievance and retain a civil rights attorney. Action. Step 6. Understand that you may sue for Fourth Amendment violations. 42 U.S. Sic. Section 1983 permits you to sue agencies for constitutional infringements. If officers searched you unlawfully following this verdict, you may possess a claim. Action. Step 7. Distribute this information to every firearm owner you know. Most concealed permit holders have no clue that disclosing their firearm doesn't grant officers search authority. Here's the final analysis. The Supreme Court just delivered a unanimous 9-0 verdict, defending both your Second Amendment right to carry firearms and your Fourth Amendment right against unreasonable searches and seizures. Officers cannot search your automobile, prolong stops, or frisk you merely because you're lawfully armed. This represents an enormous civil rights triumph beyond merely firearm rights. The court acknowledged officers were systematically violating Fourth Amendment protections by exploiting lawful carry as a pretext for searches. Yet you must understand how to activate these protections. Remaining silent won't defend you. You must declare, I do not permit searches, and I'm invoking my Fourth Amendment protections. You must deny consent and document violations. Officers will train personnel on circumvention tactics, consent requests, probable cause assertions, prolonged stops. You must be informed and resolute regarding your protections. Subscribe immediately, because the upcoming video reveals precisely what occurs if officers violate Williams and how to file a victorious civil rights lawsuit. Distribute this. To every firearm owner, they must know their protections just expanded substantially. Remember, this is instructional material regarding your constitutional protections. Always retain an attorney for particular legal circumstances. Your Second and Fourth Amendment protections just grew stronger. Exercise them. Thanks for viewing. I'll catch you in the next one, where we dissect the initial lawsuits filed under Williams and what they're securing.